This is a video reviewer for the Philippine Bar Examination. This is Bar Exam Reviewer number 4, featuring essay questions on civil law. There are 10 questions featured in this reviewer. All questions are modeled on actual questions that appeared on previous Philippine Bar Exams, covering a range of civil law topics, including obligations and contracts, property, family law, and succession. Before you proceed, please don't forget to subscribe to Review Central and click the bell icon to make sure you are notified of all new reviewers and other important updates. Let's begin. Question number 1. Alberto owns a piece of land that Bernardo has been occupying and cultivating for 20 years. Bernardo claims he has acquired ownership of the land through acquisitive prescription. Is Bernardo's claim valid? Explain. Yes, Bernardo's claim could be valid. Take note that under Article 1137 of the Philippine Civil Code, there are two types of acquisitive prescription. 1. Ownership over immovable property is acquired through ordinary acquisitive prescription after 10 years, if possession is in good faith and with just title. Or 2. Ownership over immovable property is acquired through extraordinary prescription after 30 years even without good faith or just title. Bernardo's possession of the parcel of land must meet either of these for validity. Therefore, since Bernardo's 20-year occupation meets the 10-year requirement under ordinary acquisitive prescription, his claim could be valid if his occupation of the land had been in good faith and had a just title. Without good faith or just title, Bernardo would have to wait 10 more years to claim ownership through extraordinary prescription. In summary, Bernardo's claim would be invalid if he is relying on extraordinary prescription because he hasn't yet completed the 30 years required for the same. However, if he had been in good faith and had a just title, he could still claim ownership through ordinary prescription. Question number 2. Concept of ownership. Distinguish between naked ownership and usufruct. What are the rights and obligations of a usufructuary under the Civil Code of the Philippines? Naked ownership refers to the ownership of a property stripped of its right to use and enjoy the fruits, which are vested in the usufructuary. Usufruct, on the other hand, is a real right to use and enjoy the fruits of another's property without impairing its substance. The usufructuary has the obligation to 1. Preserve the property as a prudent administrator. 2. Pay expenses for its ordinary maintenance. 3. Return the property upon termination of the usufruct, and 4. Provide security, if required, to ensure the fulfillment of these obligations. For your reference and further review, the following are the relevant laws and some selected readings to support the distinctions between naked ownership and usufruct, and the rights and obligations of a usufructuary under the Philippine Civil Code. Relevant laws. 1. Article 562 of the Civil Code defines usufruct as a real right. 2. Articles 564 to 566 of the Civil Code discuss the rights of a usufructuary to use the property and enjoy its fruits. 3. Articles 572 to 574 of the Civil Code outline the obligations of the usufructuary, including the duty of a prudent administrator. 4. Article 578 of the Civil Code discusses the obligation to return the property upon termination of the usufruct. 5. Articles 579 to 582 of the Civil Code list the requirements for providing security if demanded by the owner. And 6. Article 603 of the Civil Code discusses the extinguishment of usufruct. And here are some suggested readings for you on this topic. 1. Tolentino, Arturo M., Civil Code of the Philippines, Volume 2, Property. Includes a comprehensive explanation of usufruct and related concepts. 2. Parras, Edgardo L., Civil Code of the Philippines Annotated, Volume 2. Includes a discussion of usufruct and its practical implications. 3. Buenaventura v. Court of Appeals, GR number 126376, 1998. This jurisprudence provides a clarification of usufructuary rights. And 4. Heirs of Maria Maravilla v. Alvarado, GR number 162197, 2012. This jurisprudence provides an interpretation of obligations under usufruct. These references provide a clear legal and practical framework for the concepts discussed. Question number 3. Cora donated a parcel of land to Domain, but without delivery. Domain accepted the donation formally. Later, Cora sold the land to Esme, who took possession. Can Domain claim ownership of the land? No, Domain cannot claim ownership of the land. For a donation of immovable property to be perfected, delivery is necessary. Since there was no delivery to Domain, ownership did not transfer to him, and the subsequent sale to Esme, coupled with Esme's taking possession, effectively transferred ownership to Esme. Article 749 of the Civil Code. Take note that although Article 749 of the Civil Code primarily prescribes the formalities of a donation of immovable property, that is, public document and acceptance, the requirement of delivery is grounded in general principles of property law under the Civil Code, which states that ownership is transferred only upon delivery, even for contracts perfected by consent. Delivery of immovable property in the context of a donation is effected in the following ways. 1. Execution of a public document. And 2. Tradition or possession. In addition to the public document, actual delivery, that is, tradition, is required. This is typically done by A. Turning over the keys or documents of title, if applicable. B. Symbolic delivery, such as pointing out the boundaries of the land. Or C. Allowing the donee to take possession of the property. In the absence of delivery, the donation remains incomplete, and ownership does not transfer to the donee. Question number 4. Obligations and contracts. What are the requisites of a valid contract under the Civil Code of the Philippines? Discuss the legal effects of a contract entered into in violation of any of these requisites. Under Article 1318 of the Civil Code, the requisites of a valid contract are 1. Consent of the contracting parties. 2. Object certain that is the subject matter of the contract. And 3. Cause of the obligation that is established. A contract lacking any of these requisites is void. For example, absence of consent renders the contract null and void, while vitiated consent, such as by fraud or intimidation, makes it voidable. If the cause is unlawful, the contract is also void under Article 1409. For your reference and further review, here's a list of contracts that are inexistent and void from the beginning, as per Article 1409 of the Civil Code. 1. Those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. 2. Those which are absolutely simulated or fictitious. 3. Those whose cause or object did not exist at the time of the transaction. 4. Those whose object is outside the commerce of men. 5. Those which contemplate an impossible service. 6. Those where the intention of the parties relative to the principal object of the contract cannot be ascertained. And 7. Those expressly prohibited or declared void by law. These contracts cannot be ratified. Neither can the right to set up the defense of illegality be waived. Question number 5. X, a child of Y, was born 5 months after the marriage of Y and Z. X claims to be the legitimate child of Z. Can X be considered legitimate under Philippine law? Yes, X can be considered legitimate. Under Article 164 of the Family Code, children conceived or born during a valid marriage are presumed legitimate. This presumption is only rebutted by strong evidence of non-access or biological impossibility. Article 164 of the Family Code of the Philippines plainly and simply states,
children conceived or born during the marriage of the parents are legitimate.
Question number 6. Succession. Explain the distinction between testate and intestate succession. Under what circumstances does intestate succession govern the distribution of a decedent's estate? Testate succession occurs when the decedent leaves a will specifying how their estate is to be distributed. Intestate succession governs when 1. There is no valid will. 2. The will is void or has been lost. 3. The will fails to institute an heir or disposes only part of the estate. 4. The heirs renounce the inheritance. Or 5. The heirs are disqualified or predecease the testator. Intestate succession follows the order of preference in Articles 978 to 1014 of the Civil Code, starting with descendants, then ascendants, and collaterals. Question number 7. L, a creditor, waived the interest on a loan granted to M in exchange for prompt payment of the principal. Later, L demanded interest when M delayed payment. Is L entitled to the interest? Yes, L is entitled to the interest. The waiver of interest was conditioned on M's prompt payment of the principal. Since M failed to fulfill this condition by delaying payment, the waiver is ineffective, and L retains the right to demand interest as originally agreed. Again, while the just provided suggested answer should already be sufficient as answer to the given question in the bar exam, let us dive deeper into its details to justify our suggested answer. From the given question we have the following facts. Waiver condition. L waived interest on the loan in exchange for M's prompt payment of the principal. Subsequent event. M delayed payment, thereby failing to fulfill the condition attached to the waiver. Demand. L now seeks to enforce the original obligation for interest due to M's breach. Now let's analyze the given facts. L's waiver of interest is explicitly conditional upon M fulfilling his obligation of prompt payment. The use of the phrase, in exchange for, clearly ties the waiver to M's performance of this condition. M's delay in payment constitutes a failure to meet the condition imposed by L. According to Article 1181 of the Civil Code, a conditional obligation, or waiver in this case, is only effective if the condition is fulfilled. Since M breached the condition, the waiver does not take effect. Because the condition was not met, L retains his original right to demand interest under the terms of the original loan agreement. This is consistent with the principle that conditions must be met for conditional waivers to take effect. Contracts under the Civil Code must be performed in good faith. L acted in good faith by waiving the interest on the condition of prompt payment. M, by delaying payment, violated the principle of reciprocity inherent in contracts, justifying L's demand for interest. Question number 8. Legal easements. What are legal easements under the Civil Code of the Philippines? Provide examples and explain the obligations of the servient and dominant estates in an easement relationship. Legal easements are rights imposed by law on a property, servient estate, for the benefit of another property, dominant estate, or public interest. Examples include easements of right-of-way, Article 649, and drainage of waters, Article 637. The servient estate must allow the dominant estate to exercise the easement, while the dominant estate must exercise the right without causing undue burden and pay compensation if required. Question number 9. Vilma, a single person, donated a house to Nora under the condition that Nora cares for Vilma during Vilma's lifetime. Nora accepted and moved in with Vilma but later refused to care for Vilma. Can Vilma revoke the donation? Yes, Vilma can revoke the donation. A donation with an onerous condition, such as providing care, imposes an obligation on the donee. If Nora fails to fulfill this condition, Vilma can revoke the donation under Article 764 of the Civil Code. Here's Article 764 of the Civil Code, verbatim, for your reference and guidance.
The donor may revoke the donation if the donee fails to comply with any of the conditions which the former may have imposed upon the latter. In this case, the property shall be returned to the donor, the alienations, mortgages, and pledges made by the donee and all others who acted in bad faith being void. This action shall prescribe after 4 years from the non-compliance with the condition.
Question number 10. Family relations. Discuss the doctrine of parental authority under the Family Code. What are the circumstances under which parental authority may be suspended or terminated? Parental authority refers to the rights and duties of parents over the persons and property of their unemancipated children, as provided in Articles 209 to 225 of the Family Code. Parental authority may be suspended or terminated under these circumstances. 1. Conviction of the parent of a crime involving the child. 2. Child abuse, neglect, or abandonment. 3. Prolonged absence or incapacity of the parent. 4. The child's emancipation or death. Or 5. Adoption of the child by another party. You have just watched the Philippine Bar Examination, Reviewer Number 4, featuring essay questions on civil law. Take note that the suggested answers presented align with the typical approach and analysis expected in Philippine bar examinations, demonstrating familiarity with civil code provisions and relevant family code articles. Check out more related review videos and playlists on our channel. If you find this useful, please like and share. Leave a comment to share your thoughts or questions regarding this reviewer or any particular part of it. If you haven't done so yet, please subscribe to Review Central and click the bell button to get notified of all future reviewers and updates. Like and follow us on your favorite social media platforms. Good luck to your forthcoming bar exam, and we look forward to your long and fulfilling career as lawyer and legal professional in the Philippines.